The reason I'm taking this case is because I believe it presents a very important legal and moral issue for the country, which is whether or not Cuba should be able to exploit their population, human beings, as forced enslaved laborers in order to serve the so-called interest of the country. My entire legal career has been dedicated to fighting the abuse of power. I've been representing Holocaust survivors for over 20 years with claims against the insurance companies who sold policies to their parents and grandparents but demanded death certificates and original documents after the war and pocketed billions of dollars. Those survivors are entitled to justice. They're entitled to reclaim their family legacies, and we've been fighting that for a long time. When I was introduced to the Cuban doctors and told about their experiences with PAHO in Brazil, it was fascinating to me. Living in Miami, I was aware that the Cuban government was making a lot of money out of exporting human beings, but the details were really not very well known. So talking to the doctors and hearing about the way they were trafficked, the way they were forced to go to Brazil, the way their travel documents were taken away, the way their families were kept hostages, the way they were forced to engage in political indoctrination, how they were surveilled 24/7 by Cuban intelligence officials and then paid only a fraction of what Brazil was paying, and that the Pan American Health Organization, a US-based, UN-affiliated, OAS-affiliated entity, was the instrument of that human trafficking. It enraged me, and I felt like there must be a way to try to figure out a legal remedy here. So I dug through the statutes, I dug through the international law sources, and realized that what PAHO was doing was implementing Cuba's enterprise of human trafficking, and that it was a clear violation of international law and a violation of US anti-trafficking statutes as well, for which there was a federal remedy. So it took me several months to pull all this together, but we filed a complaint in November of 2018. We amended it in December of 2018 because we obtained cables documenting the step-by-step criminal conspiracy that PAHO engaged in with Brazil and Cuba in order to circumvent Brazilian law, violate US law, violate international law. And that case is proceeding in federal court in Miami. 3,500 of the Cuban doctors who were trafficked in Brazil by PAHO now live in the United States, and 1,500 of those reside in South Florida. So we feel that having this case decided in South Florida, where the federal law clearly provides a venue, is also very important. But in the end, this case is going to turn on PAHO's claim of immunity. And we do not believe that PAHO, which collected $100 million for its role in trafficking these Cuban doctors between Cuba and Brazil, knowing they were violating international law and US law, there's no immunity for an organization, however grand its overall mission is and however well it does other work. It does not have immunity to violate international law, human rights law, and US law. It's outside of its authority, and there's never been an international organization that's been allowed to break the law intentionally and claim immunity, and we don't think the courts would allow that here either. What is clear is that the driving force is money, that this is a major source of revenue for the Cuban government. Data shows that Cuba has collected $8 billion a year from these overseas medical missions. That's over 50% of its total budget. And so that's a huge driving force for this program. And the only way they can pocket that amount of money is by treating the doctors as slaves and giving the doctors a small fraction of the money that the foreign governments pay, pocketing the rest. And in this case, having PAHO be an intermediary and taking 5% off the top. Well, PAHO's bank accounts are in Washington, D.C., which is one of the beauties of this case, which is that Brazil and Cuba and PAHO all understood that when Brazil paid PAHO in Washington and PAHO would then pay Cuba 85% of the money, that was implicating the U.S. jurisdiction as well as the U.S. embargo of Cuba. And yet the PAHO representative who was part of these discussions, and we have cables documenting this, said it doesn't matter, this is the way it's going to work. The Director General is well aware of what it is we're trying to do. Brazil is going to pay PAHO in its city bank accounts in Washington. To begin with, it violated Brazil's laws, which required the Brazilian Congress to approve any payment from the Brazilian Federal Treasury to Cuba, a foreign government. It also violated Brazilian immigration laws, Brazilian labor laws, and Brazilian medical standards laws. It was also a violation of Brazil's Constitution, Article 5, which forbids Brazil from paying foreign workers less than it pays domestic workers. That's also a rule of the World Health Organization. The trafficking itself is a violation of international law, International Labor Organization protocols, United Nations conventions, as well as the United States Trafficking Victims Protection Act, which says that involuntary labor of this kind that's used under coercion, where travel documents are taken away, where freedoms are restricted, where wages are withheld, that's a crime under U.S. law, and there's a civil remedy for that. And the final law that was broken is the Racketeering, Influenced, and Corrupt Organizations Act under U.S. law, the RICO statute, because trafficking under the Trafficking Victims Protection Act is a predicate act for racketeering. So PAHO engaged in racketeering by engaging in a 5-year enterprise with Cuba to traffic these doctors.